lecture. And today's lecture is already known to all of you. I hereby welcome Dr. Justice Shalini Phansalkar-Joshi Madam. I welcome our chairman, vice chairman, and all esteemed members of BCMG and all of the participants. Now it is my honor to introduce today's resource person, Dr. Justice Shalini Phansalkar-Joshi Madam. Madam is the former judge of Bombay High Court, having vast experience of more than 3 decades of working as a judicial officer in various capacities as Principal Judge of City Civil and Sessions Court Mumbai, District and Sessions Court at Pune, Special Court for trial of cases of atrocities against women, Principal Magistrate of Juvenile Justice Board. She has also worked as a Judge of Family Court at Pune and then as a Registrar General of Bombay High Court. Madam has done master and doctorate in laws from Pune University in the subject of child sexual abuse from socio-legal perspective and presently on the panel of examiners for PhD candidate in Mumbai University. Madam was the joint director and then the director of Maharashtra Judicial Academy and has conducted training programs for judicial officers, police persons, public prosecutors, member of bar, probation officers, other stakeholders in national and state judicial academies and law colleges. Madam has acted as a resource person in national and international conferences. Madam's area of special interest are juvenile justice, gender justice, human rights, and constitutional laws. Madam has authored various training modules, articles, and books. Madam has the distinction of being a British scholar in the subject of gender and law and having fellowship of Commonwealth Judicial Education Institute in Canada in judicial education. With such a vast experience of judicial work of 31 long years, both the original and appellate side, and from lowest running to highest cadre, presently, Madam is busy in academic pursuit, arbitration, consultation, and mediation work. Madam is also recently appointed as a member of committee appointed by the bench of Chief Justice of India in case of Manipur violence. Very sorry, madam. I have gone through few achievements. If anything remains, I apologize you. Now I request our resource person, Dr. Justice Shalini Phansalkar-Joshi madam, to deliver the lecture on the topic of property rights in relation to matrimonial laws. Over to you, ma'am.
Thank you, Anushka, and good evening to one and all. It's a great pleasure to interact with you on the subject relating to family law. And first of all, let me also welcome you, as all of you will be joining in due course the family court. So my best wishes in advance for your examination and also for your career as family court judge. My dear friends, today we will be talking on the subject of property rights in matrimonial law. So in short, we will be talking about the matrimonial property. Surprisingly, there is no definition of matrimonial property as such, because our laws do not recognize the concept of matrimonial property. So when we are talking about the property in matrimonial law, we don't have any law as such on which we can discuss, because except for section 27 of Hindu Marriage Act, there is no other provision either in the Hindu Marriage Act or any other law which deals with the property of a person in marital relationship. And we will deal with section 27 of the Act. But prior to that, we have to understand what does it mean, the matrimonial property or property in matrimonial laws, why we don't recognize it as such. Because in our society, in Indian society, we don't recognize marriage as contract. We recognize as, we also do not recognize marriage as economic partnership. We recognize marriage as sanskar, as some religious or social function which we have to undergo, or the religious practice which we have to undergo. But in this concept of marriage, we don't recognize the non-monetary contribution of the wife. The wife looks after the family. She builds the home with her love and affection. She looks after the parents of her husband. She looks after the children. And on account of it, her husband continued to work and prosper in his career. But her contribution is considered to be non-monetary. And as a result, it is found that 60% of the women in our society are having no assets in their name. So it is a popular saying in UNO that women constitute almost half of the world population. They work 2/3 of the world's work, but the property standing in their name is only 1%, and the income which they earn is only 10%. Does it mean that women do not work? No, women work. But in monetary terms, that work is not evaluated or assessed. Then it is famously said by the economics Marshall that if a maid servant is hired, our economy will go up. But if you marry with that woman, then economy will go down because her economic contribution is not considered in our matrimonial laws. And that is something which we have to remember when we are talking of the property laws in matrimonial relationship. Why it is so? Because there are three regimes of property. One regime is separate property regime, another is community property regime, and third is deferred community property regime. We have followed the Anglo-Saxon system wherein we don't have this concept of community property. So what we have the concept, like British have the concept, that marriage has no effect on the property rights. So whatever property husband is holding, that will be his own separate property. Whatever rights wife will be holding, that will be her own separate property. It is not like both of them are bringing their individual property in common hodgepodge. Like under in HUF, we have this concept of common hodgepodge, wherein the property earned by the co-partners is brought into the common fund, common hodgepodge, and then on partition it is divided equally as per their rights of the co-partners. But that is not the concept in matrimony. In matrimony, as I said, in our system, whatever property the wife is having or she will be earning, that will be her own individual property. Whatever property husband is having or he will be earning during the subsistence of the marriage, that will be his own property. It is not that both these properties will come together and it will form a community property, joint property, in which at the time of divorce, they can say that we are having separate properties and that property will be divided equally. That is not the concept in our matrimonial laws. Our concept, as I said, is that it is both the property, both of them are having their separate properties. Hence, after the divorce or at the time of divorce or dissolution, he will be owner of his own property. She will retain her own properties. Now, just imagine what is his property as he is earning or was earning, doing the job outside the home. He was getting his contribution in monetary terms. So he was paid the salary, he is getting the GPF, he is getting all the benefits of working. But she is working in home and hence her work is not monetarily recognized. Just imagine house property is purchased. Now, naturally, the banks will insist for a fixed salary certificate so that loan can be advanced. For that purpose, some security. It may be in the form of salary or it may be in the form of some estate, land, house, etc. Now, if the flat is purchased with the loan from the bank, and considering the current prices of real estate, naturally it will be purchased with loan only. And at that time, the bank will insist for these papers, these securities. The wife who is not working may not be having those documents to get the loan. Naturally, the home or flat will be purchased in the name of the husband only. Now, the property or that flat will be standing in the name of the husband. It will be purchased from his own income. Naturally, it will become his own self-acquired property. As against it, what property the wife can have, she will have her stridhan. That will be her property, her own property. Husband may not be having any share over it. But how much stridhan a woman gets? Some few ornaments, nothing more than that. As regards the real estate property or share in the land, she may not be having till now when we are having some Hindu Succession Act, Section 6, which is amended, on account of which at times she may enforce her claim of co-partnery and get some rights in the father's property. But that is not the matrimonial property, right? That is her own self-property, because she has received it from her father as a co-partner, or she has received it as a stridhan. But her own property, matrimonial property, is not there in the marriage, because traditionally we consider woman as a nurturing or by nature bringing up the children. So she is not supposed to work. I mean, nowadays we may be working, but even otherwise, after the marriage, bearing the children, rearing them up, naturally puts a break in her good paying job. Therefore, for some years, she is having no income at all. And in this background, her economic contribution is not there at all for to have any property which can be called as matrimonial property or the property earned during the subsistence of marriage. And that makes a difference because we are having separate property regime. So on divorce, what happens? Entire property standing in the name of the husband goes to him. And what she gets, I mean, that is interesting to know. What she gets only the right of maintenance or alimony. No share in the property at all. It may be the home, it may be the household articles like, fridge, TV, car. All these articles are purchased by the husband from his own income in his name. At times it may happen that they are purchased in the joint name, but then the court will consider from whose earnings, whose savings the consideration flowed. And accordingly, court will grant that right to that person. But it will go like an ordinary property, not like a matrimonial property. So point is that in our separate property regime, which we are having in India, on the dissolution of marriage or even during subsistence of marriage, the wife is not having any claim over any of the property. As against it, if you know the community property regime, that is another regime, as I said, which is prevalent in continental system of law. It may be in Germany, it may be in France, it may be in Sweden. Wherever the continental countries are there, they follow this community property regime. It means on the marriage, both the parties property, separate properties become the joint properties of husband and wife. So if he is having some 20 lakhs of rupees or some car, home, that will be the joint property of husband and wife. Similarly, if she is having the property of her own, it will become a joint property of husband and wife. And that is in real concept, the matrimonial property. Because matrimony has generated that property in the sense that both of them coming together has the effect of having that joint property. So marriage has an impact on the property held by both of them individually. It has another effect also. It means during subsistence of the marriage, even if one of the spouse owns the property, it may be a wife or it may be a husband, then that property also becomes matrimonial property, that is joint property. In India, under separate regime, as I said to you, it doesn't become a joint property, but in continental system of law, where the community property is recognized, the community property concept or regime is recognized, there on the dissolution of marriage, whatever property both of them are holding together, it becomes equally divided. The court doesn't enter into the question as to whether the said property was purchased from the income of the husband or from the income of the wife. If it is purchased, acquired during matrimonial relations, subsistence of matrimonial relations, then both of them are having equal right over it. Even if that property is acquired before the marriage, but they are, and it is standing at the time of their marriage in their individual name, even then both will be having equal right in that property. So community property regime recognizes equal rights of both the spouses over the property owned by both of them. Naturally, the wife's right to property is recognized as such, right? Wife's right to matrimonial property is recognized as such to be equal. Why it is so? Because in continental system, they recognize the concept of marriage as a contract. Naturally, when two partners enter into contract, they assimilate whatever they have into one hodgepodge, and then when they separate, then naturally both of them will give equal rights over that property. In France, there is one more system of matrimonial laws, matrimonial property in laws. And that system is that both of them will be having their separate property. Like it is in three ways. They can have their individual properties, and at the same time, they can decide that this will be the common property between two of us. As they recognize marriage as contract at the time of entering into marriage itself, they decide and they say that this is my property. Wife will say, husband will say, this is my property. Both of them will say that this is the joint property. So whatever we earn hereafter, suppose I am earning 10,000, 5,000 will be my individual property. 5,000 I will keep in the joint family property. So that joint family fund will be then after the dissolution of marriage will be divided equally. Otherwise, whatever property they are having, they will have it. In India, as I said, we don't have this system of community property or deferred community property. There is this another concept. What it says that till the time, marriage is subsisting, he will have his own property, will be treated as individual property, but at the time of dissolution of the marriage, it will be divided equally. So during subsistence of the marriage, if the husband has acquired a property, he is having his own right of disposing of the same. And if the wife has acquired the property, then she will be having those rights. But once the marriage is dissolved, then whatever property that has remained, it will be divided equally. So these three regimes are recognized so far as property rights in matrimonial relationship is concerned. As I said, we have borrowed the system of Anglo-Saxon laws. Naturally, British people did not have this community property regime system. Subsequently, in the due course of time, they have adopted it to some extent, but till today, we have not adopted. Goa, if you know, state of Goa, which was earlier governed by the Portuguese, they still today have this continental system of community property regime. They are still today governed by the Portuguese Civil Code of 1867, and to some extent it is called as Uniform Civil Code. So there it is recognized, matrimonial property concept is recognized, and therefore whatever property is earned by both of them, it is treated as joint property, and on dissolution of marriage, it is equally divided. So to some extent, UCC, that is Uniform Civil Code or Continental System, has solved this problem. But so far as rest of India is concerned, we still are governed by the separate property regime. And therefore, if you ask me, there is no concept of matrimonial property. So as such, wife has no property except for the Stridhan, whereas husband has property because he is earning. Naturally, he is the earning member in the family, so he has the property. And on dissolution, therefore, the wife doesn't have any right in the property of the husband because we don't have this concept of matrimonial property. Now, which are the consequences or which are the implications of having a right in the property? As you know, if you have a right in the property, you can alienate the same. You can transfer the same. You can decide who will stay therein, who will not stay therein. So right of inclusion, a right of exclusion, a right of transferring, a right of giving it on rent, right of alienating, selling, all these rights follow when you are having ownership rights over the property. But if you do not have those ownership rights over the property, then you can't do any of these things. So even if wife is staying for years together in the home owned by her husband, she doesn't have the right of ownership. She doesn't have the right of transferring, selling that property, alienating it, giving it on rent, excluding someone from that home or including someone in that home. All these rights she doesn't have. Now, which right she has at present? It is the right to reside in matrimonial home. That right also earlier she did not have. We have recognized it in Domestic Violence Act. Whereas prior to the enactment of Domestic Violence Act, we had some case laws like BP Achila Anand and several other, in which Lord Dening's concept of equitable right of residence of a deserted wife was recognized. Lord Denning has considered that when the wife has built up that home, when with her love and affection that home is there, she has contributed, may not in monetary terms, but on account of her work, hard work, and everything, love and affection, then she is also having the right to reside in it. So it is her deserted wife's equity. It means her equitable right, but not the legal right. That was the concept of Lord Denning in England, which we have borrowed our Supreme Court and High Courts in our case laws. And even prior to Domestic Violence Act, we were recognizing wife's right of residence in the matrimonial home. Now, what is the matrimonial home? We know that it means matrimonial home means where husband and wife are present or residing and have intention to continue to reside. So, in such a home, we have given her under the Domestic Violence Act also, we have given the wife only the right of residence. Under that act also, we have not given her right of ownership over the matrimonial home. Therefore, she has no right of ownership even on the matrimonial home in our separate property regime, because matrimonial home is either an ancestral home which the husband has inherited from his parents, or it is his parents' home, grandparents' home, where he continues to reside after the marriage. And we all know how the decisions came after the Domestic Violence Act also, like Tarun Batra's judgment, wherein the Supreme Court also said that if the property or matrimonial home is standing in the name of grandmother, then the daughter-in-law will not have right to reside also. But thereafter, that decision is set aside, and we are having the decision stating that no, whosoever may be the owner of the house, the daughter-in-law or the wife has the right to reside therein. Now, that right cannot be called as right over the property. So, when we are talking about the rights, matrimonial property and rights therein, we have to understand two concepts. One concept is of right to ownership of the property. Another is of a right to residence. Under the DV Act, we have recognized her right to reside in the matrimonial home, but we have not recognized her right of ownership over the matrimonial home. And this is we have to remember, because her right cannot extend beyond the right of residence. So what I was saying to you is that we don't have as such the matrimonial property. We don't have any law which governs the property rights of the spouses after the marriage over their property. What right we have, what law we have is one of maintenance. That is, embedded in the need of the wife, because she has nothing to fall back upon being deserted or divorced, and hence we recognize her right of maintenance, but it is a need-based right. But we don't have the her right of economic contribution, non-economic contribution, recognizing in the terms of economy or monetary terms and giving her some right over the property. Because maintenance doesn't give the right in property. Maintenance, she makes her dependent, as and when the husband will give, or in Hindu Marriage Act, vice versa also. If the husband is dependent, then wife is supposed to give him the maintenance. So, but that is a dependency right. In need-based rights, it does not recognize economic partnership between the parties. It only recognizes that yes, she has done something and now she is coming on street, so look after her, give her some amount. It is like a need-based amount which is given to her, and therefore we do not give her more amount than is required. We consider her requirement, children's requirement, his earning, and then we grant. But even while deciding maintenance, we never say that now she doesn't have the home. And therefore, what we give again is a rent, but we don't give her the right in the matrimonial home as such, except for residence. Remember, DV Act gives right of residence, but not of ownership at all. And this distinction we have to recognize while we understand the concept of matrimonial property or property rights in matrimony. Now we may come to section 27 of Hindu Marriage Act, because as I said, this is the only section which deals with property rights in marriage. There is no other section to which you can, go for deciding the property rights in matrimonial relations. Now, what section 27 says? In the first place, it says that in any proceeding under this act, that is under Hindu Marriage Act, if any proceeding is filed either for restitution or for judicial separation or for alimony or for divorce, then in that proceeding, the court may make such provisions in the decree. So at the time of passing final order, as it deems just and proper with respect to any property. Now here we have to listen carefully. With respect to any property presented at or about the time of marriage, which may belong jointly to both the husband and the wife. So what each section says that it authorizes the court which is passing the decree of divorce or judicial separation, because decree of restitution of conjugal rights is not in that way decree where the parties are separating. So court can pass the order in the decree on being asked by the parties, and in respect of the property, only in respect of that property which is presented at or about the time of marriage, which may belong jointly to both the husband and wife. So this property is contextualized in the terms of marriage. So only if the property which was presented at the time of marriage or has any connection with the marriage in relation to the marriage, then in respect of that property, the court may pass any order, or in respect of the property which may belong jointly to both the parties. Now, which can be the property which is presented at the time of or about the time of marriage? It may be the ornaments, it may be some car or some movable property, and sometimes it may be a flat also if it is presented at the time of marriage. So not only as a consequence of marriage, but is given as a gift. Present means given as a gift at the time of marriage, and it may belong jointly. Only in this respect of that property, the family court has jurisdiction to pass the order. And the court may consider whether it is, now we are recognizing the concept of Stridhan. In Hindu Marriage Act, it is not there. But the concept of Stridhan is laid down by the Supreme Court in various judgments and said that it belongs exclusively to the woman. Husband has no right over it. That is what Supreme Court has held, even if for the time being it was held in joint custody. It is not the property of the husband because it belongs exclusively to her, like the gold ornaments given to her, Mangalsutra and other things. Then they will be her exclusive property, and the court may pass any necessary order in respect thereof or the property jointly owned by them. Now, as I said, there may not be any property jointly owned by them. For example, if husband has purchased the flat after the marriage, it is not jointly owned because it is owned by him only from his own earnings. In our law, we do not recognize as a matrimonial property, but it is his own property. So in respect of that property, which is acquired subsequent to the marriage, individual efforts, individual earning, then that cannot be a matrimonial property, and because it has got no connection as such, because it was not presented at the time of marriage or about the time of marriage, because it was earned subsequently, it was purchased subsequently, and not necessarily connected with the incidents of marriage. And therefore, in respect of such property, the court cannot pass any order. So this is something, we have to remember that the family court can pass order in respect of the property which is given at the time or about the marriage, something which has connection with the marriage. Now, at the time of marriage, Supreme Court has said that may include given prior to the marriage. For example, at the time of engagement, at the time of fixing the marriage, or just few days before the marriage, or few days after the marriage on various festivals, occasions. If some property is presented to her, then it will be also included, but not the property which has no connection with the marriage, in the sense that it has no connection with the event of the marriage. You may say that during matrimonial relationship also, if he has acquired the property, then it is in relation to marriage. No, it is not in relation to marriage, because it is a self-acquisition. It has no connection with the event of marriage. So, as a family court, you can pass the order of dividing the property only in respect of the property which is given at or about the time of marriage, or which is jointly owned by them, but not in respect of the property which is self-acquired by either of the party. She might have acquired, he might have acquired, but it has got no, you can't pass any order as such in respect of that property. The parties will have to go to the civil court to fight over their rights by stating that I have purchased. She may say that yes, it might have been purchased from his own earnings, but I have contributed in non-monetary terms. I have looked after it. Or it may be a Benami property, as someone has asked now. Benami property means earning is by him and he has purchased it in the name of the wife, then he will have to prove that it is a Benami transaction and whether it is permissible under the law. That is also to be considered, whether it was done to save the income tax, to save the capital gain tax, what was the object. So all these legal aspects will be considered by the regular civil court. So far as matrimonial property is concerned, I have to underline, I have to insist, I will emphasize that our law does not recognize property rights in matrimonial relationship. In the sense that we don't, husband and wife or two spouses do not bring their property in common hodgepodge so as to be equally divided at the time of dissolution. In the reverse system of separate property raising, her property is hers, his property is his. And naturally, in the society in which we are, only 60% of the, women are having any, or 60% of the women are not having any assets in their name, means necessarily 60% of the women do not get any property rights, any rights in the property which may be of her husband. Now you may ask me, what about the succession rights, or what about the property which he inherits? Now in that context also we have to remember that Section 6 of the Hindu Succession Act no doubt gives the daughter a co-partnery rights. Now she is made co-partner. So she is having the right in the father's property. Now, to some extent, the situation is equalizing because she is having the right in her father's property. Now, whether she exercises that right, because so many, sisters, they say that we don't want to spoil our brother's marriage life, or we don't want to spoil the peace in our natal family. We don't want to exercise that right. So that may also happen. So even if she is having equal right like her brother, she considers that at the time of marriage, my parents have given the money. So what's the point in, asking again for the right in the property? Property may be a very small portion. So at that time also she surrenders, gives up, releases that right. So she may not be having that right in the property, the law has given it to her. But whereas in her husband's ancestral or co-partnery property, whether she is having any right, Suppose husband is having 1/5 share in the joint family property. It may be a business, it may be a home, it may be some landed property. Husband is having 1/5 share. Whether during the lifetime of husband she can exercise that right? No. Her right arises or triggers only when husband dies. Till the time husband is there, she doesn't have any right in the property owned by the husband along with his family, that is joint family property. Her right becomes crystallized only on the death of her husband, and therefore under section 6 of the Hindu Succession Act, a widow gets equal right like that of her son and daughter. But if you ask me whether as a wife she gets the right, no. Only as a widow she is having that right, no, which is not during the lifetime of the husband. So what property rights a woman has, if you ask me, no. In matrimonial property, no, unless the property is acquired by her from her own income, or unless she has inherited it from her parents, got share as a co-partner, or unless she has, it is her stridhan or some property presented to her at or about the time of marriage. But so far as property acquired during subsistence of marriage, if it is acquired from the earnings of the husband, then she has no right of share, no right or share in that property. And as you know, marriage is of 20 years, 10 years, then naturally several properties are acquired. But then she, at the time of dissolution of marriage, she comes on the street because except for the right of residence, she doesn't have any other right in that home, no right of ownership, no right of property. At the most, residence and the maintenance, but property rights, no. Now, this is, in short, the concept of property rights in matrimony. Now, I have on chart, I am finding various questions being raised. So, I would like to discuss those questions. Would you like to ask, or how should I go about it? Should I read and answer those questions? Anushka, how it is to be done? Okay. Who would like to ask the question? Any query? There is one question. If the property is owned jointly by both, if he is paying. So that question means that the property is purchased in the joint name, but it is purchased from the earnings of the husband. Then that property will exclusively belong to her. She will have no right therein unless the husband recognizes it amicably. Otherwise, she doesn't have any right in the said property. So this is one question which I could find it out. Then I have read and answer what is Married Women's Property Act. Now that act gives her right in succession right, Married Women's Right to Act, that was 1874. Earlier, the wife or married daughter had absolutely no right, even the property of her father or husband. As I said, now that right is given even at least after dissolution of marriage. Okay. Now, after the death of the husband, she is having some right in the property, equal right like that of the son. But so far as the Married Women's Property Act 1874 doesn't recognize the property rights in matrimonial relationship. It recognizes the rights after the death of her husband. Previously, she was not having any right, but now, yes, after the death of her husband, she is having equal right like that of the son, but not during subsistence or during the lifetime of her husband. Next question is, ma'am, even after dissolution of marriage, where children...
Madam, I will moderate the questions. I was not
Okay,
unmuted. This is Advocate Shabnam Kazi. I'll just coordinator BCMG.
sure.
I'll just moderate the questions which are pertaining to our
Yes.
syllabus, and accordingly I'll just take it up. One of the questions is that if property is purchased by husband in the name of wife before dissolution of marriage, but after marriage, can she claim that property as matrimonial property?
No, even if it is clay purchased in her name, as I said under section 27, that property will not be considered, because under section 27, which will be the property considered? Property presented at or about the time of marriage, which may belong jointly both to husband and wife. So if the property is presented at the time of marriage, then only under section 27 it will be considered. At the time of marriage, as I said, just prior to the marriage, just after the marriage, but not some property which is purchased after with the income of one single spouse. Such property is not the matrimonial property, even though it may be purchased jointly in the name of husband and wife. Under section 27, it will not fall. It will be like, civil court decree. So under civil court, how we decide the ownership rights? We consider from whose earning it is purchased. And if it is proved that it is purchased from the earning of the husband, then her right over the property will be rejected.
There is similar question on that point. If property is brought jointly after marriage, husband and wife were earning equally, but property was purchased by husband's money. Wife has not contributed to purchase such said property, and wife has subsequently thrown away husband. Whether husband can claim this property under Section 27 of Hindu Marriage Act?
So far as Hindu Marriage Act is concerned, under section 27, there are two inconsistent views. One view says that yes, you can consider this property also, because under section 7, you are having certain rights, maybe injunction right or passing any decree. Whereas under section 27, it will not be considered as a property because it has got no connection with the event of the marriage. But assuming that under section 27 you can pass a decree, again you will have to consider from whose earning it was purchased. Maybe purchased jointly. But if it is purchased from the earnings of wife, then it will be her. If it was purchased from the earnings of the husband, it will be his property. So ultimately, like, two persons purchasing the property in the joint name, two brothers purchasing the property in the joint name. But it is proved, if there is a dispute between them and it is proved that no, though they have purchased the property in joint name, only one brother has contributed for the sale price, then the other brother will have no right, even if it was purchased in joint name. Similarly, in respect of husband and wife also, even if the property is purchased in joint name, but if it is proved that it was purchased from the income of only one spouse, then that spouse will be treated as owner and not the other spouse.
Next question, if Sridhan is not given back to the woman, which is in the custody of the other party, what can be done? I believe it is 7 only,
Yes.
but
Yes, please go ahead.
yeah. If a widow has right in husband's business and
No,
property,
Sridhan, you want me to answer again?
yeah.
Supreme Court has
If
said that
Sridhan is not given to woman and it is in the custody of other party, what can be done?
Under section 27, the necessary order can be passed directing the husband to hand over custody Stridhan to the wife. Because it was presented at the time of marriage, it is exclusively owned by her. Supreme Court has, in the judgment of Pratibha Rani versus Union of India way back in 1984 itself, has said that Stridhan exclusively belongs to the wife. And even if it is in the joint custody of husband and wife, husband has no right over the Stridhan. And if he retains it without the consent of the wife and refuses to hand over or denies to hand over it, it becomes an offense of criminal breach of trust under section 406 of IPC. Because his custody is merely that of a trustee and he cannot appropriate it to himself, he has to hand it over to the wife. So, Stridhan, yes, under section 27, the necessary order can be passed directing the husband to hand it over to the wife solely. Husband has no right in the Stridhan. But for that, first you have to ascertain that it is Stridhan. Stridhan means something which is given at the time of marriage for her own use. And more or less, it is the ornaments, which are our clothes or some household articles, mobile articles, which are given like free steaming, which are given for her own use as a Stridhan. Then yes, you can make necessary order directing the husband to hand those Stridhan articles to the wife. And this order can be passed under section 27 of Hindu Marriage Act.
Similarly, madam, there is a question on the point that what kind of court orders can be taken to pay the home loan and the EMI? Of course, there is a provision under DV Act, but they are asking whether, I believe it should be, they are speaking in relation to property rights under our Family Court Act.
So if the property is purchased by obtaining the loan from the bank, then who has purchased that property, in whose name it is purchased, and who has obtained the loan? If the property is purchased in the name of husband, then naturally he has to pay the EMIs. He cannot force the wife to do so. If the property is purchased in the name of the wife and it is from her own income, she has to pay the EMIs and loan also. But if the property is purchased in the joint name from joint income, then both of them are required to be directed to pay the EMI equally as per their contribution. If their contribution is 40-60, then the EMIs will be also in the ratio of 40-60. If it is 50-50, then in that ratio. So it depends upon how far they have contributed, in which ratio they have contributed. EMI will be also directed to be paid accordingly, but the property will be like a joint owners. Two strangers purchasing the property in the joint name. Similarly, here also, even if they are husband and wife, if they are purchasing the property joint from their own income, joint income, there is no concept of joint income, but from their own income, then naturally they will have the rights according to the contract, in the sense what was their contribution and how much loan they have taken. So in that proportion only the EMI will be directed to be paid.
Madam, you referred to community property. There is a question on it. In community property regime, are the property purchased individually before marriage are termed as joint property after marriage, or only those acquired during the subsistence of marriage are considered as joint matrimonial property?
In community property regime, whatever property both of them were having individually, maybe purchased before marriage, maybe inherited, maybe succeeded, whatever it may be, if that property was standing in their name at the time of marriage, individual name, as a result of marriage, it automatically becomes joint family property. So that is, just like after the marriage in our society, the wife automatically gets right of residence in matrimonial home. It is surely on account of the marriage, incident or event of marriage. Similarly, there, whatever property both of them are having, as a result of marriage, as an incidence of marriage, that property becomes joint property of matrimonial property. Similarly, whatever property they acquire during subsistence of marriage, that is after the marriage, they may acquire it from their own income in their individual name. Even then it becomes a joint property, community property, and therefore at the time of dissolution, it is divided equally. So you got it. There the rights of both the parties are protected in community property regime. You may be having your own individual property, but like under joint Hindu undivided family, as you know, the moment the child is born, he used to get right in whatever property was owned by the joint family. He might not have contributed anything because he is just born, he is a minor, despite he gets equal right like the adult members. Similarly, in community property regime, it may be their individual property, but as a result of marriage, as a consequence of marriage, it becomes a matrimonial property, whether acquired from their own earnings, acquired before marriage, after marriage, whatever it may be. And at a dissolution, it will be divided equally.
Next question which is asked is actually today covered by a law, but still they would want to answer it. Shridan concept, whether it is covered under Muslim law.
So what is the law?
My lady, today section 19 of DV Act covers Shridan, doesn't define or restrict it to any religion as such. So for the aggrieved person, we cover it if the property is basically with the husband or in-laws.
Correct. So now that question is answered.
I'm sorry that I discussed on it.
No, very good. Someone has to do it. But good. Yes. So the family court or magistrate court can pass the order in respect of Stridhan, which may belong to even other religion, women, wives of other religion, women of other religion, because the Domestic Violence Act is a neutral law. It is not religion specific. It is uniform law.
Next question which is asked is that, is there any time frame for filing section 27 application? The question is asked in a different form, but I understand they want to know whether there is a limitation for filing section 27 application.
No limitation as such, because section 27 says that court will pass the order at the time of passing the decree. So before the decree is passed, you can make at any time you can make that application, even in your statement of defense, that is WS or claim petition. You can make a request to that effect that court should pass this is the property in respect of which court should pass the order. So anytime, there is no limitation, there is no time limit. Before the decree is passed, request should be made either by a separate application or even in the pleading.
Next question is, husband sold ornament without her consent. Can criminal case be filed?
Yes, of course. That is because in Pratibharani judgment, Supreme Court has said that it is her exclusive property. Suppose my property is sold by someone else without my consent, then naturally it is a breach of trust. It is a cheating, especially now husband and wife having joint custody over Stridhan, in the sense that she gives the ornaments to be kept in the locker, to be kept in the cupboard's keys with both, but that doesn't give him the right of ownership. That is property kept in trust with him, and therefore if he sells that property, then it becomes a criminal breach of trust under section 406, and he is liable for prosecution and also for punishment.
Madam, but the question here comes is that will be subject to proof that he is holding it.
Yes. Of course, everything depends upon the proof now. First thing to be proved is it was Stridhan. Second thing is she had given him to, I mean, it was in his possession or in his custody. Third thing to be proved is he has sold it without her consent. So it is a criminal offense. So you have to prove all these ingredients beyond reasonable doubt. So then only he will be liable for prosecution and punishment. Otherwise not.
The next question is not directly connected to section 27, but it is connected to property rights. In case of inter-religion marriage under Special Marriage Act, whether daughter or son accrue right in property of father?
Special Marriage Act, you have to go by the Special Marriage Act. Which law will govern them?
Under the Special Marriage Act, there are specifications given as far as the rights which are concerned of the parties as such.
So whatever religion they belong.
No.
Yes.
I think I have covered most of the questions. DV Act applies to all women. That's right.
Yeah, that is always there. But remember, DV Act doesn't give you the right of ownership.
That's right. We have to come to a civil court for that.
Yes.
In case of matrimonial, it will be the family court under section 7. In
Right.
case the married couple is living separately in rented house, can the wife seek right to residence? Actually, it is not connected, but right to residence in her in-laws house based on her short living with her in-laws. It is more on a personal.
Yes, section 17 and DV Act. Right
Is
to
the right.
residence. There are case laws, as I said, Batra judgment overruled, another judgment came. So whether mother-in-law's house can be considered as a matrimonial home, all these things, but those are pertaining to right of residence, not a right of ownership or a right of property. That we have to remember the distinction very well.
Yes. Madam, all the questions are covered right now. So I would request Sonali, this is Advocate Shabnam Kazi. I would request Advocate Sonali to give the vote of thanks. Sonali?
Yes, madam.
Yeah.
Today I
give
am
the vote.
here to offer vote of thanks on behalf of Bar Council of Maharashtra and Goa. Firstly, I would like to thankful to our today's chief guest, Honorable Srimati Justice Shalini Phansalkar-Joshi madam, for enlightening us on a subject of property rights in matrimonial law. I also like to thankful to our Chairman and Vice Chairman of Bar Council of Maharashtra and Goa and all the respected members of Bar Council of Maharashtra and Goa. I also like to thankful to all the coordinators and all the participants who is participating in this lecture series. Thank you so much, ma'am.
Thank you very much and wishing you all the very best luck.
Thank you, madam.
I look forward to seeing you in the court.
Yes.
Thank you, madam. Thank you, madam.
All the best.
Thank you.